This podcast is brought to you by Bloomberg Law. For more information about our professional services for the legal industry, please call 212-617-6569.
You're listening to Bloomberg Law. I'm Charlie Pellet. This week, the U.S. Supreme Court agreed to consider whether discount retailers violate copyright laws by selling tens of billions of dollars in gray market products that were first bought overseas at a reduced price. Greg Storr of Bloomberg News wrote that the case promises to be one of the top business and consumer cases in the court term that starts in October. Michael Dunn and Josh Block of Bloomberg Law discussed the case when the U.S. Court of Appeals for the Second Circuit ruled on it in August. Here's their conversation.
Michael, will you explain the first sale doctrine? What does it allow a person who owns an authorized copy of a copyrighted work to do?
First sale doctrine is basically a codified defense to copyright infringement in the Copyright Act. And what it does is it makes the distinction clear between the actual work of authorship that's covered by copyright and the copy that is owned by the person who purchases it. So essentially what it's saying is when you go out and buy a book or a magazine or a CD, that actual physical copy that you've purchased, you are free to dispose of without permission of the copyright owner. You're basically free to sell it. There's no price restrictions, etc. Without the first sale doctrine, it would be sort of questionable as to whether or not copyright actually restricted your right to actually sell the copy that you purchased or not.
What's the policy reason for having this doctrine?
The policy reason is essentially clarity, right? And no one wants a situation, well, the theory was that for consumer rights advocates at least, no one wanted a situation where everything you purchase, you're not actually purchasing it, you're actually licensing it through some sort of complicated scheme. So you thought you had bought a book, but in reality, you've only licensed a book and you're not allowed to further sell it without getting special permission to do so.
The copyright owner gains at least on the first sale. Should they continue to gain?
Yeah, the idea would be they've already profited from selling that work to you in the first place, so anything that happens downstream is sort of separated from their rights in that work.
What was the defendant doing in the John Wiley & Sons case?
In this case, the defendant was actually a graduate student who had immigrated to the United States from Thailand, and he was actually financing his education, in part at least, from having his friends and family who are still living in various parts of Asia actually purchase foreign editions of textbooks. And these foreign editions were essentially the same as the U.S. edition, except they were printed on cheaper paper and they had cheaper binding and they were sold for a lot less money. So his friends and family were basically buying these in bulk and shipping them to him, where he was then selling them through websites like eBay and other sources at a price that's significantly cheaper than the U.S. edition was being sold for. In part, he claims to have been financing his education on that profit.
The court said that the first sale doctrine did not apply here. Why?
The court pointed to specific language in the first sale doctrine, which basically says the owner of a particular copy lawfully made under this title, referring to the Copyright Act. And the court said that language, lawfully made under this title, restricted the first sale doctrine to works that were manufactured in the United States. Granted, that's not actually what the language says, but the court said, reading it in conjunction with the rest of the Copyright Act, that's basically the way they came out. And here they said, because these works were being manufactured abroad and they weren't being manufactured in the United States, the first sale doctrine didn't apply to his resale of those works.
The court had problems here called parts of the law utterly ambiguous. They decided to read these together?
Yeah, there's another section of the Copyright Act. It's actually Section 602, which provides that the importation of a foreign work without permission of the copyright owner is infringement of the distribution right. And the court said, reading that sort of broad language in connection with the first sale doctrine didn't work, because if the first sale doctrine was interpreted to apply to foreign manufactured work, it would basically swallow the entire importation infringement situation created by Section 602. So they said the only way to reconcile these, both are very ambiguous sections of the law, the only way to reconcile the two of them together and reconcile it with some dicta from a Supreme Court decision was to say that Congress's intention was for the first sale doctrine to only apply to works that were manufactured in the United States. So it essentially, under the Second Circuit's reasoning here, if the work is made in the United States and you purchase a copy of it, you're then free to dispose of that copy as you see fit. But if the work was manufactured abroad and you purchase a copy and then try to resell it, you might very well be liable for infringing the distribution right of the foreign manufacturer.
The defendant made some compelling arguments that a decision for the copyright holder here would be bad policy. What are the policy concerns?
This creates uncertainty, essentially, right? You've bought this book and you don't know off the top of your head whether it was manufactured abroad or whether it was manufactured in the U.S., so you don't actually know what your rights are with respect to this work. Additionally, the idea that the copyright owner should have such complete control over what's done basically downstream with the work that they've already profited from selling is sort of not the traditional approach to copyright that we're used to.
The Ninth Circuit has also ruled on a first sale doctrine case. Is this opinion now in tension with what the Ninth Circuit has said about the first sale doctrine? It
is in tension. Under the Ninth Circuit standard, they also said that there's no way to square Section 602 with the first sale doctrine, and they said that if they were both interpreted to their fullest extent, basically the first sale doctrine would swallow any right to sue for infringement under 602. But what the Ninth Circuit has done, which is sort of interesting, is that they've said if the work is manufactured abroad, the first sale doctrine doesn't apply unless the work has been lawfully imported into the United States and lawfully sold in the United States. And after that point, it doesn't matter anymore whether you're purchasing the foreign edition or the U.S. edition. You're free to do whatever you want to with your copy. So basically, if the work has been sold in the United States at all legally, then after that point, it's no longer infringement for you to resell a foreign edition.
What do you see happening next here? Will these decisions be rectified?
I think they're going to have to be. The Supreme Court actually already heard a recent opinion or heard a recent dispute on this issue, and they split basically 4-4 with Justice Kagan recusing herself. And so basically, this was a challenge to the Ninth Circuit's sort of standard. And so basically, the Ninth Circuit standard was allowed to continue to exist and continue to apply, but it seems to be in direct contradiction, I guess, to what the Second Circuit is now saying. And in addition to the fact that there's a circuit split, I think there's also a lot of confusion out there now. I mean, essentially, to give a clear example, a colleague of mine here has a textbook or a recipe book actually that was manufactured in Europe, and he purchased it in Europe, and now he's trying to resell it through eBay. And under this Second Circuit's rationale, he's essentially committing copyright infringement by trying to resell something that he lawfully purchased that he thought it was completely within his rights to do. So I do think that with this decision out there, in conflict with the Ninth Circuit, and in conflict with most people's understanding of what's allowed under copyright law, I think there's going to have to be some sort of resolution to the issue.
And I wanted to ask you that very scenario. Do people in the Second Circuit, are they now infringing when they resell their books, CDs, and DVDs that they bought abroad?
It looks like it under this rationale. I mean, essentially, if you're buying something that is a foreign edition of a work, you're basically infringing the copyright unless you've specifically gotten permission to resell it from the copyright owner.
That's Josh Block and Michael Dunn of Bloomberg Law. For more information about this and other topics, subscribe to BloombergLaw.com. You can find our recent programs on our YouTube channel. Follow our daily updates on Twitter. Thank you for listening.
Copyright 2012 Bloomberg Finance LP, all rights reserved. The views expressed herein are those of the speakers and not of Bloomberg Finance LP. These discussions are for informational purposes only and should not be construed as legal advice, which has to be addressed to particular facts and circumstances involved in any given situation. Bloomberg Finance LP and its affiliated entities do not take any responsibility for the content contained herein and do not make any representation or warranty as to its completeness or accuracy.